Our next speaker, I have the great privilege of introducing, is not only a wonderful speaker, but I have the pleasure of working with him every day as my law partner and my great friend, Larry Polk. Larry, we joke about that everything Mother Teresa learned, she learned from Larry. But Larry co-chairs our securities enforcement practice. He is also the co-chair of the network's Securities SuperCourse coming up in a month right back here that I hope many of you will attend. Larry represents broker-dealers, banks, and accountants in securities litigation, securities arbitration, professional liability litigation, commercial litigation, and SEC enforcement actions. Larry represents financial institutions and their employees before self-regulated organizations such as FINRA and defends claims arising from financial transactions. He's tried numerous cases, including class actions through award and verdict, and will be speaking to us on the topic of managing the first 90 days in the Bet the Company case. And with that, let me introduce you to Larry Polk.
Well, good afternoon. It's appropriate that I'm starting my presentation at just about high noon because I'm going to be talking about a crisis that occasionally erupts with many of our clients, and that is what we call the Bet the Company case. And this is a case where the very existence of the company may be called into question, or at least it is a case where the company may suffer either reputational risk or damage to the brand. Now, managing these crises during the first 90 days is essential to a successful outcome, both from a litigation and a regulatory perspective. Conversely, missteps during these first 90 days will be greatly magnified over the following years, adding millions to legal fees and potentially adverse criminal prosecutions and regulatory outcomes. This morning or this afternoon, I'd like to share with you the experiences that I've had and my firm has had with several recent Bet the Company scenarios. Now, as Lou said, my practice focuses on financial services. So the topics that I'm going to discuss today are primarily related to banks, insurance companies, broker-dealers, investment advisors. However, the practice points that I'm going to be talking about can be applied essentially to any business that finds itself in this situation. So let's jump into the 90-day process, and we're going to start at day one. The crisis erupts. Now, what is a Bet the Company case? Well, typically it is a crisis that begins either from a disclosure of an ongoing regulatory or enforcement action, a press release from the SEC or the DOJ. It may arise from a disclosure of improper or illegal activities by past or present employees. It may arise because there has been some adverse publicity in either the print or the electronic media. And in today's world, it is as damaging to have your company's name drawn through the mud on a website as it is to see it on the front page of the New York Times and a Gretchen Morgensen article. Or finally, it may be a sudden drop in stock price that is triggered by one of these events that I've just described. So the chronology of the unfolding crisis is familiar. First, there's the adverse publicity. There's a drop in the stock price. Whistleblowers come out of the woodwork, either internally or externally, registering complaints either with the audit committee, the board of directors, or an outside regulator. The plaintiffs' counsel come out of the woodwork and begin trolling for their clients, potential plaintiffs, on websites. There is a request for information from regulators. And finally, there are the class actions that are filed. And in this scenario, the class actions take many forms. You may have class actions being filed by shareholders in the company. You may have derivative class actions being filed by shareholders ostensibly on behalf of the corporation. And finally, if the corporation has stock and employee benefit plans, you're going to have class actions being filed by participants in that plan under ERISA, claiming violations of ERISA. The first objective in this scenario is to get a hold on what the underlying facts are, what the key documents are, who are the key witnesses. And the way to achieve this is through use of an internal investigation that is typically conducted by either inside or outside counsel at the direction of the audit committee or a special committee of the board of directors. So let's talk about the internal investigations. One of the key points that you need to remember in achieving this objective that I just talked about with internal investigations is protecting the attorney-client privilege. And the reason why that's so important is in this environment, it is different from your typical attorney-client relationship in that you first have to identify who the client is that the attorney is representing. If your client is the audit committee and you're reporting to the audit committee, then communications you may be having with management of the company may fall outside the scope of the attorney-client privilege. And it can create some very uncomfortable situations if you're counsel for the audit committee and the CEO calls up and wants to know what's going on because you cannot disclose that, otherwise the privilege is at risk. So first and foremost, you have to determine who the client is to determine the scope of the attorney-client privilege and with whom that privilege resides. Now, earlier this summer, there was a very important decision out of the D.C. Circuit in the Kellogg, Brown, and Root case. And in that case, the D.C. District Court considered a motion to compel that was filed by a contractor in a civil case against KBR, asking for the files with respect to an internal investigation that KBR had conducted. The district court judge held that the attorney-client privilege did not attach because KBR was required to conduct these types of investigations pursuant to its obligations under Department of Defense regulations. So the judge reasoned, since you have to do this anyway, then the fact that you had attorneys come in does not cloak the communications in any type of privilege and ordered the company to produce the documents. The company filed a writ of mandamus to the D.C. Circuit, and the D.C. Circuit reversed the district court and held that so long as the primary purpose of the communication is to provide legal advice, then the communication is privileged, even though there also may be a parallel business reason for the communication. So keep in mind in dealing with questions of privilege, which are essential at this stage of the crisis, that there are certain best practices that you have to employ. First, as I said, you have to identify the client, keep in mind who the client is, and maintain the privilege to the control group of the client. You need to promptly identify and utilize either outside or inside counsel to conduct that investigation in order to protect the privilege. You need to provide upjohn warnings to your witnesses, and we'll talk about that in a few minutes, what that means in order to protect the privilege. Written memoranda that are prepared must state on the face of the memoranda that are being prepared at the direction of counsel for the purpose of providing legal advice. And if you use non-lawyers to conduct the interviews, which is actually what happened in the KBR case, there must be an explicit direction and instruction to the witnesses that the non-lawyers are there at the behest of company counsel or outside counsel in order to render legal advice. So then the objectives of the internal investigation, as I said, are primarily uncovering facts, uncovering documents, learning who your key witnesses are. One of the most important steps of the internal investigation, and when you first draw in the employees, is when you send out what we call the litigation hold memo. And what this is, anytime there's any type of potential regulatory, criminal, or civil action against the company needs to ensure that all documents are being preserved, both email documents and written documents. And there's an art to crafting the litigation hold memo, because typically what you put in that litigation hold memo eventually will be leaked to the press or to the plaintiff's counsel. So you need to be circumspect in terms of what you say, but to make clear to your employees that absolutely nothing can be altered or can be destroyed. The documents that are covered by your litigation hold memo ultimately will be the subject of subpoenas or document requests and follow-on litigation. And you've heard about issues that you have with spoliation of evidence. So to the extent that your employees are not following the litigation hold, then you're inviting a spoliation claim. Even worse, there is the possibility of a charge of obstruction of justice. There was a case earlier this summer, a criminal trial in federal district court in North Carolina, where the former chief audit officer of a public company received a litigation hold memo and decided to go and to clean up some personal emails in his inbox. Now, even though he was unsuccessful in deleting these because they were all being captured behind the scenes, the government filed charges against him, and he was convicted of federal obstruction of justice charges. So not only is there risk to you on the civil side, but clearly a risk on the criminal side. So now we're in the part of the process where you've conducted the internal investigation and you believe that you've uncovered some facts or evidence that may indicate a violation of a rule or regulation. So the question becomes, do I self-report this? And the answer to that question is, well, it depends. The first thing that it depends upon is the nature of the business that you're engaged in. Broker-dealers, which are governed by FINRA, are subject to FINRA Rule 4530, which says that a broker-dealer is obligated to report to FINRA any finding of a violation of an investment-related rule or regulation. So there's no discretion there. Public companies may be required to file a Form 8K disclosing certain matters. Under the Sarbanes-Oxley Act, public companies may be required, or actually are forced to disclose any finding of illegal activity by the company's outside auditors. Why do you self-report? Well, the SEC strongly encourages self-reporting by saying that we will give you credit, we will give you brownie points in any subsequent enforcement action if you come to us and tell us what you have found, because they want to have their jobs be made easier. They don't have to be going out there uncovering this if the company, in fact, has this information. Outside of the SEC, the Department of Justice has similar guidelines under what's called the McNulty Memorandum. Now, it's open for debate whether self-reporting really gains you any brownie points in a subsequent prosecution by the Department of Justice. However, that is just one other thing to consider. And once again, it's a tough decision if you're not actually required to self-report because of your business or your regulator, whether in fact to self-report. Next, I want to talk about one of the most difficult aspects of the internal investigation, and that is management of your witnesses and information. Now, I talked to you about what happens when you send out the litigation hold memo. And typically, the first thing that happens when your employees get a litigation hold memo is that they want to get on the phone with everyone else, and they want to ask, what's going on? What do you know? And it's absolutely essential in the management of internal investigation to tell your employees that they absolutely cannot communicate either verbally or by emails discussing the event or their views of the event or their perceptions. And the reason why this is important is because these emails that folks send around after the event is disclosed then become discoverable. The regulators come and do they want a complete dump of all the emails. Plaintiff's counsel will come in and ask for all the emails. And to the extent that there's communications internally by your employees talking about this event, then that becomes a piece of evidence. And to the extent that perhaps that discussion can rise to the level of an admission, then it can be used against the company in subsequent civil litigation. Even verbal communications are problematic. The reason is if you get involved in an enforcement action with the SEC, during subsequent verbal examinations that the SEC will conduct of your employees, one of the first questions they ask, the SEC attorney will ask is, have you discussed this matter with anyone? And to the extent that your employees have been talking amongst each other, even innocent communications can rise to the level of a civil conspiracy or an obstruction charge. So it's very difficult because, of course, people want to talk. They want to gain a better understanding. And it is so important to restrict your employees' ability to engage in these types of communications. So how do you restrict that communication? One of the ways is through effective use of experts and consultants. It's important in a bet the company case to retain an outside PR firm to deal with the request for information that will bombard the company, that will bombard management after disclosure of the event. And it's better to retain a PR firm for two reasons. One is, if you use an outside PR firm, as opposed to internal resources, then perhaps that internal resource is not going to be subject to subpoena, or will not be, there's not going to be claimed there is some admission in the communications from the internal resource. Use the PR firm to craft your message to the press, to investors. Use your PR firm to craft your message to your employees, because it can be devastating to your workforce to read things about the company that are in the print media, in the electronic media, and not know what's going on or how to respond. So use that PR firm to your advantage. Consulting experts are very important to be retained early on. In a financial fraud case, it's essential to have a forensic accountant to come in and do an analysis of the alleged financial fraud to find out where the money went, whether there really is any problem there. Use your consulting outside experts for document preservation to anticipate the e-discovery that surely will come when the regulators and the plaintiffs file their actions. And finally, just one practice point, when you deal with an expert, just make sure that you have a clear understanding on the front end with respect to budgeting and bills. Otherwise, you're going to get a nasty surprise when that first set of bills comes from your consulting expert. And lastly, I'm going to talk about the preparation for the follow-on civil litigation. Now, inevitably, as a result of this process, you're going to see, as I said, you're going to see class actions, you're going to see individual claimants or plaintiffs filing claims, you're going to see claims being filed by the regulators, either as part of an investigation or ripening into enforcement action, possibly even criminal actions. So in dealing with this process, you may be dealing with 3 or 4 different sets of attorneys, outside attorneys, representing different aspects of the case. To further complicate the matter, you may be dealing with individual attorneys representing individual witnesses. You're going to hear about whistleblowers later this afternoon, which are a real problem now in terms of trying to get your hands around the internal investigation and what's going on. The whistleblowers may also be entitled to independent counsel. So it's very important during these initial days as the litigation is ripening that you have conference calls amongst counsel with perhaps a joint defense agreement to discuss strategy, to craft pleadings, to craft discovery responses. It is also very helpful to create an extranet or a doc room where you can put all the key documents, store witnesses' testimony, store pleadings, and make that available to all of the attorneys working on the case so that you make sure when you have multiple different groups of attorneys representing you that everyone is working off the same book and page and everyone has the same basic message in terms of how to deal with the unfolding crisis. So in a little bit less than 20 minutes, I try to give you an overview of what's going to happen in the first 90 days. It's obviously a very complicated scenario, but the steps that you take during that first 90 days, as I first told you, are really essential to managing the process and ensuring that the company emerges from this crisis unscathed, or at least with a limited damage to the company and to its brand. Thank you very much.